Thank you for joining me in this video. I want to talk to you today about errors and omission insurance. There was a time when errors and omission insurance was not mandatory within the real estate system. Some brokers chose to do what they called self-insure. What that means, they carried no insurance at all, and they figured that the money that they would have paid for premiums, they could put aside and use in case of a lawsuit. And if they were sued for, say, $50,000, they could handle it. But if they're sued for $500,000, they'd probably have to go bankrupt. Well, RICO came along and made it part of the licensing program that we must carry errors and omission insurance, and we must carry it through their carrier. And that doesn't give us the option to shop around and get the best rate, but it does guarantee that there's universal coverage if you're involved with another brokerage and something goes south. And it's handy, very, very handy to have that assurance. And errors and omission insurance not only covers errors and omission, it also covers a deposit if there's something that a brokerage goes bankrupt or dipping into their trust account or something, and it covers agents' commission as well. So there's a number of protections with errors and omission insurance. One of the things I find is a lot of people get confused between errors and omission insurance and our governing body, RICO, when it comes to a complaint. And I want you to understand that although RICO collects the premiums for errors and omission and selects the carrier, it's a totally different entity. If you get a complaint going into RICO and you have to file a response, you've got to be careful what you say. You got to be truthful and honest. That's important. But I don't want an agent writing their response and to say, I guess I screwed up here. I should have done this. You don't want to make a statement that implies liability. If you're talking to your insurer, you can have that kind of a conversation because they're in your court. So RICO is very much like a prosecuting attorney checking to find out whether there's enough to continue prosecuting you. They're a consumer protection advocacy group, and that's what their first mandate is when it comes to a complaint. Understand that they can fine you, but they can't award a damage to the consumer. So they need to know that, and if the consumer is looking for damages, they're going to launch a lawsuit against you, and that's where errors and omission insurance come in. Your errors and omission has a couple of very important components. One is that it's a first dollar legal fee. That means if you get sued, you don't have to hire a lawyer. You don't have to worry about the bills accumulating for a legal defense. You hand over the errors and omission people, and they assign a lawyer, and they create the paperwork and defend you through the process. It's also subject to a $2,500 deductible, and that $2,500 deductible increases to $5,000 deductible if you have a second claim within the calendar year. So it's important to understand that. They won't get involved in a commission dispute. So if you're fighting the seller over commission, errors and omission will not get involved. And there's certain things that they won't cover. If you're doing an appraisal, for example, and that appraisal is used for financing purposes, they won't cover that. So you may want to do additional insurance if you get involved in that kind of a thing, property management, something that perhaps is not covered in errors and omission insurance. It's also a claims-made basis where as soon as you understand there's a possibility of legal action, you need to open a file with errors and omission. It may come to nothing, but if you don't, you know about it and you let it go and you let it go, they may well not cover you because they think you could be saying a lot of things that could damage your position. But the Achilles heel with errors and omission is this $2,500 deductible. And understand that insurance companies are companies. They're there to make a profit, so they want to make a profit. When you go through the legal process, first of all, the lawyer for the plaintiff and the lawyer for the defense gets back and forth and swaps documents and claims and counterclaims and all sorts of things. At some point in time, they have an investigation for discovery, and everything's kind of on the table, and then they have what's called a settlement hearing. And a settlement hearing in front of a judge is an informal opportunity to see if they can horse trade and come up with something that both parties can live with without pursuing it further in the courts. And the problem comes up if the complainant is willing to settle for something below at or around $2,500. Once that happens, the insurance company is going to back off. Even if they know you're not at fault and you know you're not at fault, they're not prepared to spend an awful lot more money defending it. I mean, let's say the settlement was $3,000. That means the insurance company is going to pay $500. Well, they'll spend that in an hour on legal maneuvering, and so they're going to encourage you to settle. I got a friend who's an investor, and he's got a tenant who is determined to milk him for as much money as he can. He's gone on record saying he's not going to move out unless he gets $50,000, and he creates all kinds of imaginary situations. And so he put forward a claim that he fell down the stairs. There wasn't adequate lighting into the basement apartment, wasn't adequate railing. And so he launched a lawsuit. Didn't hire a lawyer. Of course, he wouldn't spend any money. But he launched a lawsuit, and the investor property owner involved his insurance, his PL and PD insurance, and they came to bat for him. And in the settlement conference, it was agreed that the tenant would accept $2,000. Well, that's the end of the discussion. The insurance company said, you'll have to pay it because it was lower than his deductible, and the insurance company could get out without any more exposure. And that's what happens with your errors and omission insurance. Once it becomes around the figure that the insurance company says it doesn't make sense to fight any longer, then they're going to say to you, you need to settle. Now, they can't force you to settle. But if you don't settle, they're going to say, okay, we are going to withdraw our legal defense. You got to hire your own lawyer. You're on your own. And if the claim is higher than this, then you're on your own to pay it. So you're pretty much obligated to pay it. Understand that that's the way the process works. I think they need to have a deductible. I understand that. But it does create an Achilles heel, as I say. You need to be aware of it. And if and when it happens, you need to understand that there's going to be times. Hopefully you won't get a claim against you, but anybody can launch a lawsuit. They launch a frivolous lawsuit against you. It could well invoke your $2,500 deductible. Thank you very much for investing your time, and look forward to talking to you again next week.